Hi, you probably are watching this video because you just got a packet of documents from us about discovery, and you're looking at it and you don't want to deal with it. But guess what? We're probably going to have to. You probably have a little bit of law knowledge from watching movies and TV shows growing up. I did before I went to law school. One of my favorites was My Cousin Vinny. If you've ever seen it, you remember there's a scene during the trial that the state of, I forget even what state it was in, that the state offers a witness that was a surprise witness to the defense team. Wasn't on the witness list anywhere. And the defense attorney, Joe Pesci's character, Vinny, our protagonist, goes up to the bench and makes a very excellent objection and is overruled. But despite that, he made a good objection. He wasn't aware going into trial that this person was going to testify. He wasn't aware what they were going to say or how strong their argument was going to be, or had no opportunity to prepare to defend against that argument. That's what discovery is for. There are three general sections of discovery packet that you probably have before you, two of them for sure. One of them is interrogatories. Those are questions you have to answer. And the second set is the request for the production of documents. Those are things that the other side is requesting that you gather, documents that you should have available to you. For example, your bank records, or perhaps text messages between you and your wife. Those things are discoverable by the other side. And before you ask me, yes, we can do it too. We can put together a set of documents and ask them questions, ask them for a bunch of stuff. And then the third thing possibly you have on there is a request for admissions. Probably don't see that, but if it's in your set, they're requesting that you admit or deny certain things, which we can do. Now, you're probably going to look through that set and decide there are things you really don't want to answer. If you find those things, we should discuss them, but please understand that the rules are very expansive. And so in general, it's very hard to avoid answering a question completely unless there is a clear legal privilege, such as an attorney-client privilege or a doctor-patient privilege. On that point, one of the common questions I get is, well, what about my mental and physical health? They aren't allowed to ask me about that, are they? Well, if you have a custody case, they are. The mental and physical health of the parents are relevant topics to be brought up in a custody case, and sometimes even the children too. How long do I have to do this process? 28 days is the rule according to the Ohio Civil Procedure rules. That said, we have to have an opportunity to go through your answers and offer any objections or maybe clean it up, make sure that we have the answer in such a way that we aren't giving too much away. And so you really should do it in 14 days if you can. Get them back to us so we have an opportunity to review. What if I need more time? In general, you can ask for more time. The other side's supposed to give it to you if you reasonably ask, but if you're starting to get towards trial date and there's not a lot of time left, the court's going to start getting antsy and you're going to have to answer with enough time that the other side can review and prepare for trial. Do I really have to get 3 years of financials together, including all my bank records? That would be annoying. Yeah, and yeah, you do. Once you gather those documents though, we can review them and decide if they're actually relevant to your case. Oftentimes, bank records are requested in cases where they're not relevant anymore. But that said, rather than have a phone conversation with me every time you see a question that you don't like, which would add to your attorney's fees, the most efficient solution is just answer everything. And then once you have everything answered, call me and let's talk about it. And you can bring up all of your concerns in one telephone call. We can decide if there's anything we're going to object to or limit out, and then give them a complete packet in one shot. I'm doing this video primarily because I've watched a lot of my former clients waste time and legal fees fighting the discovery process, or not doing it at all. And then when we're up against a deadline, scrambling and spending a lot of time doing it with our help at the last minute. Rather than put that kind of money out, it is better that you take this set, just answer it, and then send it back to us, and then we'll discuss. That's the fastest and cleanest way to get through the discovery process, and I think your bill and your pocketbook will appreciate you if you follow that advice. Thank you.